Many of you are new to Keller Williams Memorial. Welcome. I'm Marilyn O'Neill. I'm the Risk and Compliance Manager. And what Betty just asked me is to tell some things that'll scare you. But what I am going to tell you is from a listing agent perspective. We had an issue last week and it was very interesting. You know how you might be the second listing agent? Or maybe you're the third listing agent? I always wanted to be the third because they had really gotten to reality by that time. You know, the property was on the market for a year. Now they really wanted to sell it. But anyway, here's what's interesting. If you are a listing agent and the previous listing terminated, did not expire. Everybody understand the difference? Terminate would mean that the agreement ended early. Expire means I gave you this much and it's over and now you can go and enter into agency with another broker. Be very careful. You as that second listing agent or the third one must have in your possession the termination of listing from the terminated listing, and I'm going to tell you why. Normally when you release a seller early, there is a form that we use. It's called termination of listing. And in that termination of listing, the seller is just not free to enter into agency with anybody or to fire you unless they're going to threaten you. If they threaten you and said you breached the listing, you're going to sign that sucker as soon as possible with no strings attached and get it back to the other seller. You want it over. But in the instance that a seller comes early to a listing agent and says, I want to terminate our agreement, the listing broker agent has the right to say, okay, here are the terms for our termination. And in some instances, they ask for a flat fee that will be given so that the listing broker and agent can sign the release, and now those sellers are free to enter into agency with another broker. But in some instances on that form, they may use the provision that says, I want you to pay me no matter who comes to this property for this length of time. So there's other provisions on that form. We had never seen those other paragraphs marked before, and the listing agent was provided a copy because they have a contract under this second listing agent. They got it sold, put it under contract, it's at title, ready to close, and lo and behold, the first listing agent has tried to interfere, and she sent the invoice that the seller must pay. As the second listing agent, under a previously terminated listing, you had to explain to the sellers what it meant that they might have to pay two brokers compensation. And the duty is on you as the second listing agent. In other words, no seller should ever pay two brokers without knowing what they're going to have to do and being provided proper notice by the second broker. In other words, if that first broker wanted to have money if you sold it in the next 3 months to anyone, then what would happen is the new listing agent would have to say, oh, Mr. and Mrs. Seller, this prevents you from entering into contract with another party without having to pay the previous broker and myself. No seller wants to pay commission to two separate brokers. And the clarification from our TAR legal, because they made up that form, our attorneys thought the form stunk because it wasn't clear and it looked like it extended beyond termination, which it did. It had an ending date of almost 3 months later. And you know, a seller, TREC always advises that a seller cannot be punished. In other words, we can't punish the seller and say, we're not going to let you list it with another broker. Now that's TREC's interpretation. TAR is our association. And they said, no, these are our agreements that we created to protect the brokers and the agents. And we want provisions in these documents that would give that first broker who was fired early the chance to recoup any fees that they might have incurred. So again, that's kind of been a new revelation. Most of the time within Keller Williams, I've never had that where our agents have done it. I did one time, and it was for a multi-million-dollar property. They wanted to fire the listing agent soon. The listing agent had paid a bunch of money for professional staging, professional photography, brochures, and in their listing agreement, they said, if you terminate early, you're going to owe me this much money. And the seller signed it. And then the seller says, I'm not paying you. Whoop. Well, the seller has breached the agreement. There is contractual obligation. We could go to a civil court. And so the seller just said, well, then I won't sell my home until this agreement is over. Well, that's exactly what he did. He would not pay the termination fee. And these are legally binding agreements. We don't typically have agents putting in early termination fees. But if you do, you have to explain it to the seller. If you leave before the agreement ends, if you try and fire me, you will owe our brokerage this money. So again, you have to be real careful. If you put things in that, you have to explain it very well before they sign it, and you've got to prove that you've explained it well. The best way is for them to initial that part, even though the initials are at the bottom of the form. Anytime you want to bring somebody's attention to something, what do? You have them initial it. That's what we have found.
My very first listing, the sellers terminated. They just changed their mind, decided not to sell.
That's a different matter.
Over $2 million off of leads from that house.
Yeah, and I'll be honest, if somebody doesn't want me, this is my personal opinion, I want it to be over as of yesterday. Right. If you don't want me and I don't want you, let's make this over. Let's clearly do it. But there's some people that are not like that. And sure, if you've expended hard dollars and you've got receipts to verify all what you've spent, there's nothing wrong with trying to recoup your monies. Yes?
I currently have a listing now where it was terminated. I told them to terminate the listing with the other agent right at that page 72. But the other agent said, I'm not signing the agreement, but the contract is terminated.
Yeah, you have to be very careful. Number one, how did these sellers come to your attention? You didn't go to them.
No.
They came to you. And that's it. All you can do is talk about in the future when you are free, this is what I'd like to do. You can't assist them nor tell them to terminate or how to get the form or to provide the form. Oh, no, that's a violation. No, you cannot. Those are copyrighted forms. That other broker can nail you and it would be guaranteed. You interfered with their listing. We don't give people forms that doesn't apply. Okay? And you didn't terminate your listing. You were helping them terminate the previous listing. That's the mistake. Okay, we don't do that.
Okay, so how do you say or how do you do it when they say, okay, I'm not happy with your other agent?
I understand that you're not happy with your other agent, but I can't help you with that matter. We can talk about the way I work, how I would market your property, and what I'll do if you have a listing with me. But as far as your other agreement, you must take care of that and have that concluded before I can become your listing agent.
Must take care of it, but you
That's what I
can't tell
said.
them
Yeah,
terminate.
they have to take care of it. Now, once they said, oh, I fixed it, I've taken care of it, and I said, well, in the computer, I see where it says withdrawn. That means they didn't take care of it. So then you would say, I need you to provide the termination of listing, that in writing that the agent or the broker agreed to terminate the listing.
Okay.
It's a very big difference.
If you go back on the computer, if you say terminate, it doesn't mean they did it, but if you say withdraw, they did.
Withdrawn, they still have an active listing. And that's, they use that many times when the parties cannot reach agreement and the listing broker knows that nobody else will be able to list that property until it is terminated or expired in MLS.
So look for those who expire.
Yeah, you want to make sure that as the second listing agent, you don't assist them in learning how to fire their first one. That's not part of our duty. That's a violation of the Code of Ethics. The other thing is you're going to be very careful about working with sellers and making sure that the sellers, I am going to tell you just from a form usage, and we'll get, next time we're going to talk about some Trek legal cases from our legal updates that we have. Just remember, as a listing agent, don't ever have a seller sign a contract document at time of listing. A seller can only have in the file documents that are completed and that are appropriate for the time and the transaction. In other words, we have a lot of listing agents who love to have the sellers sign the addendum for mandatory membership in a property owners association, and it's a violation to misuse a form at the wrong time. So just remember, when you're sellers, you're only going to have them sign forms. Don't have them sign an intermediary relationship notice when it doesn't apply yet. All the types of forms that are inappropriate at the time of listing, they're only done when it presents itself. In other words, when it is actually the right time to do that. Okay. Everybody's got the handouts and signed up?
We have a question.
Okay.
So if the seller has agreed that intermediary is okay, can we put the intermediary document on the MOS as a doc, even though the seller has not signed it?
Absolutely not.
Because then if that discloses stuff.
Right. And if you as the listing agent, if you get an offer on your property from an agent in your operation, you will immediately provide that notice to the buyer agent.
And then what is your recommendation? Can we go forward if the buyer has not signed in negotiation?
I would not feel comfortable as a listing agent representing a seller when the broker is in an intermediary position.
And we don't have the signature from the buyer.
Right. The buyer would have to sign that document and send it your way. Your seller will never sign the document until it's completed,
Okay,
but you could certainly provide that document
okay.
to the buyer agent at that time and then say, please remember, I need this signed by your buyer at time of offer so that the seller can review it and acknowledge it.
So not before.
No, I don't want it before. It's not the right time. A listing agent controls that because they know if this buyer agent is a part of their operation. In other words, they know when a broker will become an intermediary. Yes?
So on that note, if the buyer agent is going to be making an offer on a listing that's in our office, shouldn't they supply the intermediary?
Well, they would, but in your case, because you said that there could be notations on it. In other words, the listing agent may have had prior business arrangements or transactions with the seller. At that point in time, you're going to say, thank you, you submitted the intermediary relationship notice. We have to send this one back because this reflects the relationship information that I need your buyer to acknowledge prior to the offer being considered. It's really, it's really funny. I visited with a broker this morning, and they were talking about the requirements for compliance and all of the various forms. And I said, if I had my list, I would probably add forms. It would be more than what you turn in. And the reason is for a very simple reason. If you provide notice to the party you represent, or maybe others that you might be required to, like the TAR 2513, which is the Disclosure of Residential Service Contract, if you provide notice to your clients are never going to say what? You didn't tell me. That's what I want no client to ever say again to a Keller Williams agent. You didn't tell me. And so while you look at it as volumes of paper, I look at it as I want you to be armed with every possible notification and warning to your clients, because it shows I am looking out for your best interest. You're complaining because you have to sign one more form. I'm worried that something could happen to you, and it's great material that I just sent your way. You need to be aware of this. People, truthfully, and how many of you have been licensed for over 20 years? Okay. And what happened years ago, our contract forms were very small. They were short. Why do you think we have an 8-page contract and the 9th page is receipts and all that? Do you know why? Because brokers have been sued. Sellers have been sued. And so what happens is, based upon what happens in transactions, they accumulate all this data. Those brokers and lawyers on the TREC Broker Lawyer Commission and the attorneys for TREC, they all look at that TAR. They keep a huge database. One of the things is we have provided information because of situations our agents have been in that have been the result of a lot of the TREC cases that you'll find in the TREC Legal Update, as well as the Broker Responsibility Course. It's really bad when I could see my name on 7 cases. that meant I knew the outcome. And I was reading it. They changed the names to protect the innocent. But after a while, you're reading it, and you're going, I remember this. And I remember how devastating it was for the buyer agent. So again, the notices that we want you to present to your clients, it's not because we want one more piece of paper. You have to look at it from the standpoint, you are a fiduciary to your clients. There's nothing wrong with you advising them properly, giving them notice. That's your job. Our problem would be is if you fail to do that and something happened, then they might have a legitimate issue that says, well, you didn't tell me. You didn't tell me that I needed to get it inspected. You just threw that form at me before closing because you said you won't get paid if you don't sign this. We know when all the dates are. And we know that if you didn't do it at the right time, that's not going to save you. Doing it at the right time is the only thing that will save you. Okay? Just because you want to get paid, that has no bearing on the timing of it. Okay? So you have to do things at the right time, otherwise you could be in trouble. Okay, great. What we're going to talk about today are the addenda to the contracts and all of its various contingencies. And we have a situation where these contingencies that we're going to talk about in many of these addenda, you don't use them all the time because the transaction dictates. And when you don't use them a lot, you might not remember what the provisions are. But most of these addenda that we'll talk about today may have automatic termination clauses. In other words, the contract's over and no one has to give notice. You know how when a buyer under the termination option, they must give notice within the last day of their option period before 5 p.m. In my book, it would be like the day before, but anyway. They have to comply with that. They have to give written notice. Well, a lot of these addenda that we're going to talk about, they have hurt buyer's agents in this office who failed to pay attention to what the addendum meant for their clients. So we're going to go through that. We're going to talk in general about what addendums are. We're going to do third-party finance, I promise, until you all get it right. And how I judge that is if I have 30 calls or less a week on this matter, I'm thinking we're doing pretty good. Okay? But if that number doesn't get smaller, then I'm going to present it to you every time because several of you are new. And when you're new, you can go through all the training that you want, but I'm going to tell you, until you are face-to-face doing it for your client, you see things very differently. And all of a sudden you go, oh, I remember that, but what does that mean? Or what should I put in here? So again, third party is going to be something I'm going to talk about until you all have it perfectly down, okay? Because it has caused a lot of money from agents' pockets to be given to their former clients. A lot, and we don't want that to happen. The next one is the addendum for lead-based paint. Gosh, that addendum is attached to the contract, and it's a federal mandate, and you still don't get it right. And so we're going to work on that today, too. The addendum for sale of other property, that's a unique one that only happens occasionally when the transaction needs it. The addendum for property subject to a mandatory membership in a property owners association, we used to call that the HOA. This is because years ago, 20 plus years, it was homeowners association. And so what happens, that addendum as well as third party are probably the most common addendum that we see attached to our contracts. So we're going to go through those. Then we're going to do the backup contract addendum and the short sale addendum. Okay. And so what is an addendum? What are addenda? Addenda is the plural form. It is from a Latin word. And so the individual is an addendum, but the addenda is the plural form. Now, what are they? Are they agreements between the parties? Yes, and they are a part of the contract. That's why when you get an executed contract, if you don't have all the proper addenda all signed at the right time and notated in the contract, they won't apply. The biggest offense of this is probably the seller's temporary residential lease. Agents don't have it at the time of contract execution. Instead, the parties might agree to it, in the transaction, and they say, oh, we need to do this. They do it, but they don't place it on an amendment to the contract, notate in paragraph 9 that paragraph 22 is changed to add the seller's temporary residential lease. So here we have this thing out here that says I'm a part of the contract, but you have never, ever gotten the parties to agree to add it to the contract. That's what the amendment does. We don't ever do anything after execution of contract without an amendment, okay? And so we see that there's a disconnect, there's a gap. We'll have a seller's temporary residential lease appear, and all of a sudden we're thinking, where's the amendment to show that it's attached to the contract agreed upon by all parties? We see signatures, but that's not what we need. We need the amendment with it. Are all addenda sent to the lender and the title company? Absolutely. I had, over the weekend, I had an agent call me, and she said, Marilyn, I have a buyer's agent who said, we have to remove the notation about there's a tenant in the property and from the contract because we can't let the lender know there's a tenant in the property. And so she was calling me as a listing agent. She said, my seller and I'm a little concerned. I said, it's called fraud. Yeah. You can tell your seller that you and your seller will not participate in any fraud. Lender will know everything. We don't conceal anything. What was kind of strange is that the buyer agent said it. We don't want the lender to know. That didn't even have to come like, what are they trying to do? They said to you exactly what they're going to do. They're going to conceal a material fact about the contract and agreement between the parties from the lender. That's crazy. We had one time, and it was real interesting. The buyer agent sent over 2 amendments. Okay, I have 2 amendments that we're sending. One of them that is just going to be between the buyer and seller, and the lender and title company won't get that one. Then this other one we'll send to the title company and lender. And the listing agent called me and she said, they put it in writing, Marilyn. I said, golly, I don't want people like that in our industry. I don't know about you, but that scared me. What if they said that to an agent who didn't, maybe it was their first transaction, or you know what I'm saying, they're new, and they wouldn't think, God, this other agent's been in the business a while, wouldn't they know better? And don't ever make that assumption, they do know better. If you hear something that somebody's telling you, either as a listing agent or as a buyer's agent, be very cordial to them. Don't become confrontational. Don't challenge them. And then you pick up the phone and you call me, and I'll tell you if they're barking up the wrong tree. Okay? Many times, and I've had this, where agents, we've had it done to agents in this office. An agent who used to be here went off on their own, comes back, and she said, well, that agent just doesn't know what they're doing, and they're inexperienced. And I thought, you're pointing the finger at somebody, and they all should be pointing back at you. What on earth possessed you to do that? That was wrong. Do you know what I'm saying? And here they are accusing you of doing something wrong, and they didn't do it right either. So again, just, be cordial. But if you kind of think this just doesn't seem right, or this doesn't feel right, and the agent on call says, you know what, I don't know about this, or I don't know the particulars about it, just remember you can pick up a phone and talk to me, okay, and I'll let you know. What I don't like is someone taking advantage of you because they found out you haven't had many closed transactions, or you're new to our business. And the minute, I'm not going to say this as a general rule, but if it's somebody who's saying you have to do this, that bothers me right there. That kind of sounds like maybe, what do they mean? I have to do this, or my client has, you know what I'm saying? It just, those kind of trigger type points. And really, when we go through these addenda, you have to think of it from the standpoint of who are you representing? Or do you have from a buyer's perspective, or do you have a seller's perspective? Your time limits will be very different depending upon the addenda as well as the party that you represent. But no matter what, you have to explain these addenda perfectly to your clients before they initial and sign it. And if you aren't sure, you can't say something to somebody unless you're sure and certain. You can't assume. You can't send it through .lib or DocuSign and say, please sign these. You have to explain them to them. That's your duty and your obligation to your client. They don't get to sign anything without you having explained it and reviewed. And most of the time it's going to take you reading the form first, making sure you understand it, and then if you don't understand it, you're going to call and verify the use of the form, because you never want to communicate it incorrectly to your client. That will get you into trouble, even innocently, or just not realizing something, or you've never used it before. And again, as I said earlier, the problem with some of these addenda is that they have no requirement for notice to the other party, but automatic termination features. And we had a situation in this office that I'll explain on one of them that was deadly consequences. Buyers have lost properties and then they've sued the buyer's agent because the buyer agent didn't advise them to extend the date. And all it is a matter of extending the dates many times for them to be compliant. Okay, let's do third-party financing addendum. Okay. Whose contingency is this addendum for? Buyer. Only the buyer. The poor seller, all they get to do is what? Initial and sign it. And sit it back and hold their breath. And pray their buyer is individually approved and the property approves, right? Poor seller, the whole time you're explaining it and they're initialing it and signing it, you're going to say this is the document where you have to hold your breath. Okay? And it's deadly. It's deadly from a seller's perspective because what are they doing? They're just sitting and waiting for actions of the buyers. You feel helpless when you're just sitting back and waiting. Now in this third-party addendum, the very first paragraph, A, is the type of financing, okay? And do you notice in the first paragraph it says duty to apply? Yes, well, if buyer's agents did what I recommended over a year and a half ago, the buyers under these new trade regulations would already be done. All their taxes would be sent and filed and everything would be fine. The lender would always be waiting for the survey, executed contract, and an appraisal. In other words, the buyers had done their due diligence before. Their duty had been satisfied before. But we have buyers who haven't done that. So the buyers have to know you have a duty to apply promptly for this, okay? And as a buyer's agent, you wouldn't want a buyer to not have gotten a conditional approval letter. That would be just not very good on your part if you're representing a buyer. So paragraph A is really based upon the conditional approval letter by the lender, right? You didn't make that information up. The lender provided it. And on that conditional approval letter, the lender's given you terms. That's what paragraph A is. The buyer is saying to the seller, look, Mr. and Mrs. Seller, I'm going to use this type of financing, and these are the terms. If I don't get this, I get to terminate the contract and give you notice within a number of days in B1. So again, it is a contingency for the buyer. They get to tell the seller, look, I didn't get that interest rate. I get to terminate and get my earnest money back. They have to perform properly and give notice properly, otherwise they won't have it. But this is what paragraph A is for, the buyer's ability to get these terms, and if they don't get these terms, they can terminate the contract. Okay? Does everybody understand that they shouldn't be making this up with their client? The buyer's sitting over in a conference room somewhere? Yeah, don't do that. We had last week an agent says, well, as the listing agent, we didn't like that the interest rate was so low because the market's changing right now. And I can appreciate that. The seller probably was a little concerned. The problem is that the seller may not be able to dictate that the buyer change that. That is at the buyer's discretion. And the buyers are usually not going to be advised by their buyer agent to take that risk, are they? No. You as a buyer's agent would never say take that risk. The lenders provided it, so why would the buyer agent step in and say, oh yeah, it's fine, we'll go up a couple of points? No, that takes away a lot of that provision that the contingency provided for a buyer. So again, while sellers may not like it, they can maybe say, you know, we would look more favorably if the interest rate on your terms was this on a seller's invitation, but they run that risk that the buyer's going to say, no, I don't want to do that, okay? So again, this is a buyer's contingency. Paragraph A is pretty simple. Paragraph B, on page 2, everybody flip it over, is what causes all the problems, and it's B1 and B2. B1 says very clearly that the buyer must meet approval, okay? There is only one fill in the blank on B1, and it's within the number of days that a buyer would have to perform giving notice to the seller, okay? Now, it's a number of days here. So, for instance, say we had 15 days in there. On the 10th day, you would have a visit with your buyer and follow up in an email saying, what is your status on getting the terms that we had on paragraph A or your individual approval? And so the buyer needs to go to their lender and find out. About 2 days later, you said, you know, we visited a couple of days ago. Today is probably our D-Day to make a determination, because in the event you want to ask for more time for approval, we have to have all that tied up in a nice little bow before these number of days. That's the problem for the buyer. I think the biggest thing for buyer's agents, they communicate to the lender, is everything okay? And the lender says everything's fine. Okay, everything is never fine. Okay? They mean well. They just want you to go away. Okay? That's what it means. If a buyer relies upon what the lender says, and then it turns out not to be true, they always want to roll on you, the buyer agent. That's why I said within 3 days of these number of days passing, your buyer has to make a hard decision. Did you get individual approval? Do you want more time? And did you get those terms? No ifs, ands, or buts. Yes?
Okay, so let's say that it's 15 days that we put into this contract. You're saying a few days before that 15 days.
Yes, ma'am. On the 12th day, it would be D-Day. On the 10th day, you've already had a visit because they might have already just ended their option, so they're going forward. You know, you don't usually talk about it in the option period because they're more focused on making sure, is this the property I want to go forward with? My thought is if you have a buyer who hasn't even made a determination and a commitment to a lender, you're going to be talking about that from day one of the contract. It's going to be based upon what you know of the buyer's process. Okay. Yes, ma'am.
Can you extend B1, the number of days?
I was going to get to that. When a buyer says, you know what, Marilyn, I've been with the lender told me I'm about 55% there, and you're going to say, do you like those odds? And they said, no, I want to wait. But the lender said, I need 8 more days, and they could get me maybe to 90%. Okay, that will be a date. On the amendment in paragraph, it gives you the ability to extend these numbers of days to a date, and it's the amendment to the contract. It's paragraph 8. Okay, it's very clear what you would have to do as a buyer's agent. Now, I am going to tell you, just because you send it over to the seller doesn't mean the seller has accepted it. Until you receive it back signed and executed, it's not a part of the contract. We had a lot of agents who said, well, I sent it over within the number of days. That may be true, but you didn't get it back. So you can't let it go. You'd have to go to the buyer, say you sent it in, and it's 3 days before the number of days, and you've asked for a length of time extended, and you didn't get it. And on that last day, you're going to say to the buyer, look, we have not gotten this signed by the seller. Based upon this, I advise you to terminate if you don't want to take the risk, not only of not being individually approved, but of losing everything. The sellers have the right to hold you in default, paragraph 15. It's just not about earnest money. Okay, and under today's climates, I have more sellers since 2015 who have sued buyers for more than earnest money. Sellers have gone into another lease, they put earnest money down on new construction and they're going to lose it, or they're in a contract and they're not able to extricate themselves from that contract, so they're out real money and they're not happy. So again, you have to be on top of this as a buyer's agent, otherwise you're going to be in considerable difficulty with your client and could be subject to a TREC complaint. Most of our TREC complaints, when they blame the buyer agent for not telling them and keeping them informed about these number of days, the buyer agent lost every time. Not only did they lose money, but they have a permanent record at TREC that says that they were sanctioned and fined. And that's what we want to avoid. That's why when I talk about these things, these are things you can do. These are your processes that you will do forever, and you won't have to be faced with that. Yes?
One question for you. Like the B1, you choose this contract something from the buyer that you don't know the approval. You said 15 days, but if you were the close date is about the 5 weeks, 35 days. Why you ask the 15 days for approval, right? You can ask the 21 days.
Oh, the buyer, I didn't say that the buyer couldn't ask. I gave an example as 15 days because it's easier for me to kind of figure it.
My question is, if you have enough time to close, like 30 days, and then you just extend about the approval day, you will close the still 90 days, right?
No. The number of days in B1 is just the contingency window for the buyer. It's not about final approval ever. Final approval only comes in about 4 days before closing. Okay? So it is not about final approval. So a buyer couldn't think that they had to have final approval. Okay? They're just being cautious about how much have I approved already by the lender. No lender would give them final approval until 4 days before closing. Period. So again, it's just a matter of time. It's not an entitlement by the buyer. I knew a seller. I'm related to him, and we received an offer on our condo in Port Aransas, and he looked at the third-party financing addendum. They wanted 30 days. He said, not in anybody's world would I ever give this buyer 30 days. He said 10 minutes. I said 10 minutes, I'm a little more negotiable than that. So I came up with a number of days, but that was his perspective. And I'm going to tell you, he took a risk. I said, if we come back with shorter number of days, I understand 30 is ridiculous, but I said, let's look at something else. He said, no, I've already investigated him. I've pulled up his company. I've checked his records out. He did a little bit of research on this buyer. And he says, I'm willing to give him 15 days. I said, okay, well, if they walk and we don't go forward, that's fine. He said, no, that's fine. Well, you know what? It's amazing what it did. Within the option period, when we negotiated a shorter length of time on the number of days, they actually, when they submitted their amendment, they moved the closing date up. Apparently, they got on the stick and got it done. And they closed early. So, it was a risk that my husband was willing to take. He didn't want to give them a bunch of time. He said, no, they either can find out right now if they're approved or not. I'm not going to put my hopes in their being closing when they have a free walk up to the day of closing. And so it was kind of interesting because it was a risk that the seller took, but that's their choice. Don't ever tell a seller they have to accept what a buyer has offered. Okay, just remember, especially on fill in the blanks. Yes, ma'am.
Okay, so I'm new, and I'm asking questions. So what is normally the norm as the amount of days?
Well, you know what's interesting? Before the TRID regulations, it was everywhere, okay? And buyer's agents did a really good job trying to provide as much time for a buyer, because that's your job, right? And all your buyer has to know, look, we're going to put in 25 days or 30 days, but there's no guarantee. It'll be based upon what the seller was willing to accept or counter. Well, we have proven over and over that some listing agents don't read it because they don't counter it. And so it benefits your buyer that way. There's nothing wrong when you represent a buyer. You really are obligated to always ask in the buyer's best interest. Now, the buyer can say, well, what do you normally see? Well, say, based upon our compliance, they normally see between 15 and 20 days now. We used to see a lot more, but once the TRID regulations came in, I think listing agents really did a much better job explaining this addendum to their sellers, and they're paying more attention to it. And so we're seeing a shorter amount of time in B1 than we had seen previously. Okay, I think, as I said, I think listing agents are doing a much better job really reviewing it and telling a seller what this contingency for the buyer means. Okay. Now, any more questions? Yes, sir.
Now, B1 doesn't really cover, maybe we should talk about it just a little bit. If they get like 10 days extra to secure financing back here.
They won't get 10 days extra here. That would be on the amendment,
Right.
and it's a final date.
Right, but we need to be aware that it's their earnest money can still, if that period slides by.
Well, that's what I said. It's great consequences for a buyer that doesn't make a decision to either give notice and terminate or they run the risk of not only, everybody says that you'll lose your earnest money. They are dead wrong. They could lose everything. Paragraph 15 doesn't say just earnest money. While that's a provision, the seller has more provisions. And I have said, I have found sellers coming after them for lease monies, for losing a house that they wanted, the earnest money they put on a new construction that they're not going to close on. I've seen them come after the buyers for a lot more.
There's not a way other than what it's already stated in to address this issue for some of your sellers, is there?
This is not a seller addendum.
I'm sorry, a buyer's.
Okay.
So if a buyer says, yeah, I understand.
You better put it in email.
Okay.
Yeah, prior. You know that first email I want you to send? Well, you're going to send a second one, and you're going to reiterate it again. And again, 3 days before this days passes or that date passes, you better have a final decision from your buyers. They really need to kind of be thinking in that mode. While they may have 3 more days, you don't want them to go out of town, not be able to sign the notice. The notices are valid per the contract, and that's what's a problem for the buyer. They have to give notice. Yes.
To make sure, when you give a notice as a buyer representative, they will have their money back. If they have to cancel because they're not able to buy the property, and they give notice before those days that we got here expire, they will receive their earnest money back?
Correct. If they give notice to the seller within those number of days, they're entitled to receive their earnest money back. Their option fee was paid for a different reason. They'll never get that back unless it's credited at closing and funding. But yes, they would get their earnest money back if they gave proper notice. Yes.
Can you speak a little to the approval here versus final approval? Because my buyers always go in with an approval where everything's been submitted in writing, we have an approval letter. But this is not final approval. It always comes back with conditions that have to be cleared before closing.
Right, and every buyer needs to know you're not going to give final approval until 4 days before closing.
So there's still some risk.
Oh, there is. Half the time, we find out that something hasn't been done properly, or something came to light, or buyers lied about child support, or not telling them that they paid child support. All sorts of stuff comes up. IRS problems. They didn't file their taxes. So, yeah, the buyers are, until they get that final approval, they are at risk. But at this point, they don't have a contingency if they're past the number of days.
They're never going to have final approval before this is expired.
No, usually not until 4 days before closing. Now, in the event that they do have final approval, B1 will have the second box marked. In other words, this contract is not contingent upon buyer reaching approval. Those are the buyers that I'm talking about that have done everything before offer. All the lender's waiting for is the executed contract, the survey, and the commitment, as well as the appraisal. Okay? Otherwise, they're all worried. Yes?
Even if the loan is approved, they get pulled out within those last 18, 20 days from the milestone. Even if the loan is approved.
Well, they don't have an ability, if the loan is approved, say for instance you have a buyer, and we had this happen last year. The buyer and the seller got crosswise. Buyer decided to say, they didn't negotiate well during the option. Buyer didn't get what they wanted. It still ate them because it was about winning. So the buyer said, okay, I've got those number of days. I'll terminate pursuant to that. Well, we had the seller, and we had told the seller, as good listing agents, we had the seller say, you really need to pick up the phone and talk to this lender yourself. They did. They did it before the offer. When they got the notice of termination from the buyer pursuant to this number of days, man, that seller was on the phone, grabbed that phone, called that lender, and the lender didn't lie. The lender said, no, sir, what I told you several weeks ago still holds. They are individually approved, and there is no problem. That buyer lost. Yeah. See, the lender, while the lender doesn't have to provide a letter for B1, it better be the truth. Okay? The buyer can't be making this up. It better be backed up. If they get a call, the lender gets a call, because the lenders will not lie. Yeah. And we had that, and it was interesting because the seller knew it was about winning because he wanted to win too. And so, when you have a buyer and seller who both want to win, sometimes it doesn't work out that way. So, but the sellers, the listing agent did what I'd have requested. The sellers need to do their due diligence. The same way my seller did, my husband, he had already checked all of this out. I was still looking at other parts and doing my net sheet and things for the offer that we got from the listing agent. So I was looking at it from a different perspective. I wanted a number, and he was looking at the detail on the contract, a number of days, and what he would respond to. Everybody's different. You can have two sellers in front of you, and they may never agree upon anything, but ultimately they are both going to have to agree if they sign that contract. Okay, they're going to both agree to those. So B2, here's the deal. The buyers have to know, look, you can be individually approved, but we're still holding our breath just like the seller is. We need the property to meet approval. That can include appraisal. It has to meet value. Most lenders want it to meet value in order to give the loan. It has to be insurable, okay? And by insurable, meaning to you and the buyer, if the buyer says my premium is $5,000 a year for my homeowners, the buyer might say, I don't want it to be $5,000. I don't want the property if it's $5,000. That's why buyers have to get their insurance quote during their option period. They don't have the right to say, I don't like that high premium. If it's insurable, the lender is going to say it's insurable. The property has met approval. Your buyers have to do due diligence at the proper time. And then in the city of Houston, we have a lot of issues that come up where the buyer didn't do their due diligence about insurance until very close to the end. And the buyer was in default because the buyer didn't want to pay the premium that they were going to be faced with. They could have easily found out in their option period and terminated and gotten their earnest money back. Instead, the sellers sued them because the sellers had moved out, gone on to another property, and they were not expecting the buyers to not close on a property that they had a contract on. So again, there's certain things buyers have to do their due diligence during their option period. The appraisal is usually done probably about mid-cycle now of the contract terms. If it's much later than that, listing agents now know the buyer has some problems being approved, because the lenders put the order in for an appraisal right away, but the lender won't really confirm that the appraisal will be done. They don't want a buyer, their borrower, to spend monies if they're really not certain that they're individually approved. So before the TRID regulations came in, I thought that would go away. Do you know what I'm saying? I thought that buyers would be certainly approved mainly before the appraisal was done. And I thought this is going to be a little bit better improvement. The problem is the lenders still have the discretion to say don't appraise it yet. Okay? So listing agents, if the appraisal isn't done in a timely fashion, you're going to know that there is an issue. And if the lender says no, there's no issue, well, that's because they're not going to tell you. Okay, because most lenders like to get everything done in the right order and done ahead of time so that they can clear all those hurdles. And B2 is about property being appraised. If your buyer says the appraisal just came back, it met value, but it has 300 square feet less than what we saw on the appraisal district, can your buyer terminate the contract?
Yeah.
Absolutely not. These contracts are not about square footage. So from the very moment you start to show property to your buyers, you're going to say, this house will have the same square footage today, the first time we see it, and to the day you walk through before you close and fund. We're not changing the square footage. It's the same. It's a number. And that's what causes problems. Some buyers, the house hasn't changed. It's the numbers that have changed. Either it was disclosed through the appraisal district information, or it could have been through a previous appraisal, whatever it was. The buyer cannot rely upon square footage. If they want it to be a certain square footage, they're probably going to have to pay a fee to have it measured during their option period. That's less than the appraisal part, okay? But a buyer can't say, I'm not buying it because it's not the same square footage. They might nail the listing agent if the listing agent knew that the square footage was different and didn't advise properly. They could, but they'd have to have a fact that the listing agent knew it was different. Yes?
This is the question. I had, I have a listing, and they have two sources of square footage, and it's 350. One says 3907, one says 3905 or 6, something. There is going to be a problem that, of course, the seller wants to use the higher. And I tried to convince him to.
Well, you have to put in agent remarks that buyers must independently verify square footage. There are discrepancies between appraisal districts or appraisal sources.
Okay.
Yeah, just advise the buyer's agent. And if the buyer agent doesn't read, it's on them.
Hopefully the potential buyers have already seen the house, they have to decide, yeah, this is big enough.
Well, I know, and most of them do. We've all been there. We've put the furniture in the room mentally, and we're thinking, okay, this is great. This is an awfully small bedroom. Some people would call it a closet in Texas. When I lived in other states, it's called bedrooms. Texas is different. We have bigger things. But yeah, you're right. And every argument, we had an agent here whose buyer was an engineer. He was not going to let this go. I'm in a charity golf tournament for KW Cares, and I get the call from her buyer. And I said, sir, has the house changed the square footage from the first time you met it and saw it? He did not like that. He closed on that property. See, that's the problem. It's the same square footage the first time he went through the house. It hasn't changed. It's a number. And he kept saying, I'm not going to pay more than $50 a square foot. Well, the moment you hear your buyer say that, you're going to say, guess what? Now you get to spend a lot more money during the option period, because this is not about square footage. It could come in 1,000 square feet less, and if it meets value, you are still in it. The property has met approval. Now, in this paragraph, you have to have a formal declination from the lender. Buyers cannot terminate with this provision without the lender providing it. It's a HUD form that is a standardized form, and that lender is going to be all over it saying it did not meet value. Okay, that's the only way B2 will work for your buyers, if they give notice. Time is of the essence for this paragraph? Yes. What does that mean, time is of the essence? Can somebody talk about that?
You have to act in a certain time frame.
Absolutely. It's a certainty. You don't get to fudge it. You don't get to be outside of that time frame. You either give notice within those number of days, or this notice doesn't apply anymore. You don't have a contingency. Property approval is to the date of closing. So sellers, that's why sellers hold their breath till the end, because there is no time limit for property approval. Only for buyer approval, meaning getting the terms in A or individually approved. Okay, that's the only time there's a time limit. Okay, now everybody's got that down pat? Okay, we're going to go to the next addendum. All right, next addendum. Addendum for lead-based paint. Have y'all ever seen this before? Really? Oh, I don't think so. How many boxes are on this page? Okay, it's an equal opportunity form for buyers and sellers. They each get at least 2 boxes. Okay, do I know how much each one of those boxes is worth? I'm going to tell you, because a buyer agent was sued. It's worth $25,000. That's what they had to pay when their buyer sued them, because they left them unmarked. They allowed their buyers to sign this document and not mark their boxes. Okay, so as a listing agent, I'm going to talk to you first. Number 1, this is what you have to do as a listing agent. Dear Mr. and Mrs. Seller, it is your obligation not only to complete 1 box in B1 and 1 box in B2, but you must give the lead-based paint pamphlet to a prospective purchaser prior to offer. Okay, that's your job, Mr. and Mrs. Seller. Listing agents, if you don't deliver it and show that you delivered that pamphlet, you have failed in your duty for your sellers. Bottom line, they can come after you. That's your job. I've had a lot of listing agents try and argue with me, and unfortunately, whatever their buyer has to deliver, they're required to deliver it for their seller. So a buyer has to receive it. Okay. Now, as a buyer's agent, I am going to tell you that most listing agents don't read, so they don't know that their seller is required by law to provide that pamphlet to the buyer. So as a buyer's agent, you're going to give it to your buyer. Okay, make sure your buyer gets it. The fact that the sellers didn't do their job, I fault their agent for that, because nobody reads these forms, and the listing agent should know what they need to do for their sellers. The sellers have marked one box in B1 and one box in B2. And then the buyer gets the form. Of course, the seller signed and dated, so has the listing agent signed and dated. In this instance, we're going to talk about a great, awesome listing agent. She provided the pamphlet with this addendum to the buyer agent. Buyer agent gets it, and they say to the buyer, look, this is what the seller has marked in B1 and B2. Now you must mark a box in B, C, and D. Okay? In C, you're only going to mark one box. And in D, it could be several boxes. You could have received information from the seller about lead assessment on their property or lead report, as well as having received the pamphlet. Okay, this is a federal mandated. This has to be done perfectly every time. One of the brokers here in Houston said that HUD came in and decided to audit all of the brokers' records. And they did it for the lead-based paint addendum. Every box that was not marked was $200. And they reviewed every file that the broker had ever had. They have the right to do that. That's federal law. That's how they know you met compliance. So that's why I'm trying to tell you, it could be devastating impact for the brokerage operation, because we do a lot of volume. So that's why we're real particular about it. The only time you're in real serious trouble is if you've already closed. You cannot go back to your client and have them acknowledge anything. It's too late for you, okay? So don't do, after it's closed, that's not how it works. Because they could easily testify, oh yeah, they came to me after it closed and had me sign a document. You know what I'm saying? That would just be deadly. So again, don't do that. But I am going to tell you that this form is the most misused form. Listing agents don't get it done right. They pass it on to the buyers. They don't deliver the pamphlet. They don't prove that they delivered the pamphlet for their sellers. And then buyers, agents don't review it with their buyers. They must send it to them to say, sign this, and they do. They sign and date it and never mark the boxes appropriately. Yes, ma'am.
What is your recommendation as buyer agents when you get the document, the listing agent has provided us, and B1 and 2 is not completed?
You're going to send it back to the listing agent. If there's not a box in B1 and one in B2, as a listing agent, you're going to say the buyer noticed that the seller failed to provide the proper notification by marking one of the boxes. The buyer said they will not sign it. Please have your sellers complete it properly and send it back to us. Now at that point, the sellers have to mark the box and initial it because they've already signed it. See, once you sign it, it says it's done. You've taken, just like our contracts. We don't go back to the contracts. They're signed. We go to an amendment. So just remember, if anything is asked of you after the fact, I had an agent who walked around the corner and marked the boxes themselves and brought it back to me. Obviously, they didn't think I was smart enough to realize that I had just given it to them to fix. So again, we know when I know you don't have buyers and sellers in your back pocket, so when you turn it back in just like that, we know that it wasn't the right party doing that checking. Okay? Yes?
As a listing agent, if you attach it as a document in MLS, or
It's attached to the seller's disclosure.
right, so does that constitute having given it, about having it attached in MLS listing as a document?
No. MLS is just a courtesy. You would have had to instruct them in writing to please download the documents and name them in that you have posted in MLS and provide it with your offer. That's what you have to do. That is your job to deliver it. In other words, and if they don't present it to you when you get that offer, you're going to have to then deliver it to them and prove that you delivered it.
But if they downloaded it and delivered it with the
Yeah,
offer,
yeah. And good buyer's agents, they know that, they know where to find these things and they know what to look for. It would be a problem if the agents don't pay attention to that, but a listing agent, you would definitely want to make sure it was done right and done at the right sequence and time. Yes, ma'am.
So we're dealing with a listing agent that's missing in action, or is cray-cray, or just doesn't like to be told that she messed up. And in an offer, we have the right, when we receive a seller's disclosure that's incomplete, we can always go back and request for the seller's disclosure to be provided so many days after the offer. Can we put that in there too?
Yeah, it's-
That's what we're finding. We're finding many good buyer agents are losing out on deals because they can't get good information from the listing agent.
Yeah, and there is some point, as a buyer's agent requesting for an updated seller's disclosure and all the documents, when you request it and they don't do it, now your buyer has the call. How do you want to do this? Do you want to go forward and accept it the way it is? Or do you want to terminate? Or do you want to not go forward and withdraw your offer? So it's a buyer's call, and they're going to have to make the call. I'll be real honest. I've been around the block a few times. I don't believe anything anybody puts on a seller's disclosure. That's the real truth. I have sat in 23 depositions for this one lawsuit, and we're going to go to trial in May. And I don't believe anything a seller says. They all lie. Or they misrepresent or they forget. You know, it's a combination of things. It's not that they all lie, it's just they could forget. They misrepresent or think it wasn't important, I shouldn't have done that. I wouldn't rely upon any of it. I mean, it's really sad, isn't it? In that condo that we sold, we had a listing broker. Do you think it was me? I don't think so. I wouldn't list my own property forever. Did I have a contract that the attorney was on? You bet I hired an attorney. Did I put everything through that attorney for the attorney to deliver to the listing agent? You bet. Did I buy Seller Shield online for $199? Oh, absolutely. And it was a property management. It was a condotel. I never lived there. So, but I wasn't going to take any risk. I know how litigious people are. And the fact that I disclosed everything is very obvious because the property management failed to disclose it to me. Property management is a deadly real estate practice. Do you know what I'm saying? Poor property managers. They have to be perfect. They really do. They have to know everything that's going on. And it's hard. Sometimes they don't. But again, I'm not going to ever, say that a seller lied on the disclosure. They could have misrepresented. They could have forgotten. It could be a combination of things. We have had some sellers who have willfully lied. We have one under this deposition where the builder says, I signed that warranty document even though I knew it wasn't a warranty. How could a builder who builds in this town still get on the stand and say that? I can't tell you the name of them, but boy howdy, I'd put my whole compliance team on alert if any contract comes in with that builder. That's different. The brokers can. But I'm going to say, that's the problem. We deal with people who just twist things or misrepresent or know they're doing something wrong and they don't care. It's amazing. So again, I wouldn't let the lack of a seller's disclosure stop me. If I was a buyer and I really wanted the property, I'd just get in there and inspect the you-know-what out of it. Inspections are not cheap, and they shouldn't be. Right now we're getting into the summer months. If you have a buyer and he does not have an HVAC company come out during his option period and pay for it to be inspected, you better rethink what you do with buyers. Most of them are advertising big sales right now. It's amazing. You don't want us to have the seller tell you about their AC unit, do you? I wouldn't trust a seller if they told me everything was working. That's why buyers need to do their due diligence, and HVAC is the most important one because we use our HVAC system heavily with air conditioning almost 12 months out of it. This year it probably was 12 months. we had a little freeze and I lost everything. Remember that? I woke up and it said 11 degrees on my thermostat, and I said, 11? No, and you know, I went up to it and I tapped it. It was real early in the morning. 11 degrees, and I go to the back door and I open it and went, oh my gosh, I lost everything. And the day before it had been 70.
Yeah, it was like, 80.
I love the weather.
So Marilyn, are you saying the general inspection where they inspect the HVAC is not sufficient, that they should have?
Correct.
separate-
A truck inspector, unless they're a licensed HVAC, cannot penetrate that device. Truck inspectors are surface. They don't get to take it apart. They don't get to pull the coils. They don't get to see that it's not going to work next week. But HVAC people are. They're licensed. HVAC. They're licensed heating and air conditioning technicians, yes.
Are there special technicians for pools too?
Oh, absolutely. Let me tell you, a pool is a hole in the ground. Does anybody dispute that? Okay. So here's what would happen. If I had a buyer we want a pool. I'm thinking, really? I don't think so. But anyway, you want a pool. Now, here's what you're going to do. You're going to hire a pool company, a really good pool company who can do it. Now you have to hire a pool leak detection company. Two different kinds. Pool companies may not have the ability to detect leaks. Okay, they can tell you kind of surface. They're like the truck inspector. They'll check things. But they can't tell you that there is no leak in the pool. Every property that's ever had foundation repair work, the pool is cracked. And yet buyer's agents didn't advise them to have the leak detection determine if there's a crack in the pool. So again, absolutely, you're going to inspect the world out of a pool. Yes?
So we have pool inspectors, again, track, like the general inspection, you should get a pool inspection, but you're saying that's not adequate, we need a pool company and.
The pool inspection can be done by, I would only have it done by a reputable pool company.
Not by a track.
Yeah, truck inspector is fine, but I think what I'm trying to tell you is while they do certain things, I would rather result in somebody who does that for a living. That's what they're going to do. Detecting leaks is different than a pool inspection. So we've got lots of issues that have been horrible, especially with, everybody says, oh, the pool's just evaporated and lost water. And then after we closed and funded on it, we found out that the seller was paying $600 and $700 a month on water. So as a buyer's agent, if there's a pool, you're going to ask for the seller to give you their last 6 months of water bills. Do you know what I'm saying? There's some things you just cannot leave to not asking for. If they don't want to give it to you, then you tell the buyer, I think this is the time to leave. Yes?
How these work for agency, we would tell customers, we would give them the amount of the monthly bills, and say the highest was X number of dollars, the lowest was X number of dollars.
Right.
Can they do that with the water company?
I don't know. The last time we got sued on that, the new owners, the buyers went in, they got all the water bills because they were the owners. That's when they turned and sued. The agent didn't ask for it during time of option. In other words, when a buyer would probably like to know that the seller's been spending $600 a month on water. But oh, it's just evaporation. That's what we were told. Yeah, I don't think so. Somehow, I don't buy that. Any other question? Yes, ma'am.
Do you have to disclose if certain damage has been repaired?
Personally, if I were a seller and there was damage and you repaired it, I would disclose it. I would disclose it. I live in the world of disclosing too much because they've never sued you over disclosing too much. It's when, and here's what's so funny, every time I go to the attorneys, including the ones that started Seller Shield and the one who sits on the broker lawyer committee, they said, Marilyn, if your agent says to you, do we have to disclose? You tell them, you don't even need to call me. You tell them, the fact you asked if they have to disclose tells you they better disclose. And that's what we really want agents to do a much better job of as listing agents. No seller has been sued when they disclose too much. My seller's disclosure for my little 1,000 square foot condo that we had never lived in was 62 pages long. I showed the inspection when I bought it 7 years ago. I showed the inspection that I had done before I put it on the market. Marilyn, now why did you inspect something before you listed it for sale? Why do you think I did that? Because I fixed everything. I wanted to be able to show them this is what we had done, and here are all the receipts for all the repairs that we had done, based on that inspection report when I put it on the market. You see the difference? There's a right way to help sellers. Not being afraid to talk about these things. You got to get over that. This is the real world. Well, it's not just protecting yourself, which I care about you. I'm talking about sellers. Yeah. When I worked for sellers, they knew that I was not somebody who hadn't been through everything, because sellers lied to me about the properties I owned. I lost everything. That's why I'm working the way I do today. I will work forever. And it almost took somebody's life. So again, I don't trust sellers, and you better not trust them either. You can respect them, but just be very cautious about it. I'm not saying this about all sellers, but you know, they can forget. Oh, I forgot. That's innocent, isn't it? That wasn't purposeful or hurtful, but it could devastate somebody else. Well, personally, it was. They knew I didn't mind being the third listing agent either, but they knew that if they didn't tell the truth, I was going to fire them, because I was in it for the long haul. This was an industry I committed and paid a lot of money to be in. So a seller lying and me getting caught as a listing agent was never going to work. Period. Nobody got to lie to me. Once I found out they lied, they all were fired. Yes?
I have one question. Actually, we will have the offer, and the seller is going to say, the house was built in 1968, but they choose, the seller has no report of the seller has no actual knowledge of the legal based case.
Well, they might not.
Yes, they are investor. But how can I,
No, the sellers have to fill that out truthfully.
Yes, they feel this both of that. We got this, but how can I, advise my buyer first get, inspected?
Well, the buyer, if they want to do a lead assessment, they're going to need a very long option period, because there's not very many of them in this area, and it takes a long time to schedule one. So if the buyer wants to do their own lead assessment, they're going to have to account for that with a very long option period.
Okay, but this one they say like they buy the right, is the number 2, they have the, it's within the 14 days after.
And no, it says within 10 days after the effective date, they're going to have a lead assessment. Yeah.
2 weeks is enough for the buyer get
It might not be. You may have to modify that. You have to call and find out when they can schedule it. There's not a bunch of lead assessors, so it's subject to being able to get that report back within a very short period of time and getting an appointment done.
Okay, and another question is the buyer agent is responsibility to give the buyer the pamphlet.
I told you that if the seller fails to deliver it, because it is their duty to deliver it to the buyer, you as the buyer agent are going to give it to them. Yeah, don't let it go. If the listing agent doesn't do what the seller is required to do, you need to deliver it to the buyer. Yes?
Okay, I have a question, because I had a piece of property that had 2 houses on it, and it was going to be sold as commercial property, and so the houses were going to be torn down, and they were built in the 50s, so they still need to.
Absolutely, it's federal law, even if they're tear down. Yeah, we had sellers sued because they didn't do that, and it was tear down. This house had no windows, no HVAC, no doors, and they didn't do that lead-based paint, and that was brought up in the lawsuit. They got nailed for that too. The listing agent didn't advise them. The seller is obligated by law to complete it. Yeah, even if it's a tear down. Yes?
Marilyn, who offers the seller's shield?
Who offers it? Only the listing agent.
How do I find out what company so I can with future deals to?
It's www.sellersshield.com.
Thank you.
Yes.
Is there one for asbestos?
There's another form for environmental issues, the addendum that you can attach to the contract.
Just environmental.
Yeah, yeah, it's environmental assessments, and it could be mold, it could be all sorts of assessments, endangered species, that type of thing.
So how do you cover yourself on those?
You just attach the addendum to the contract. The buyer says they're going to do the report within so many days and give it to the seller. Yeah. Yes, there was another question?
You can only get seller's shield for closing, right?
No, you can pay, you'll pay $2.99 at closing if you're a seller. I went online when I listed my property and paid $1.99.
Even if it's ready to close.
Oh, it's too late if it's already closed. Yeah, no, everything has to be done before close. That's how it works, yes. Seller's Shield is a legal contract that sellers can have in the event after the closing and funding, if they get a demand letter from a buyer, they have this legal contract with Seller's Shield. Seller's Shield would provide them 80 hours of legal assistance, and that's equating to about $20,000. $199, $20,000. $199, $20,000. I don't know about you, but the $199 looked really good to me. $299 looked good, but they had this special now that if you do it online, you get it for $199. Okay, the next addendum that we're going to talk about is the addendum for sale of other property. And again, this one is not used often, and that's why agents tend to not pay attention to it in detail that they really need to as buyer's agents. Listing agents too have to pay attention to it. It's just not a form that is required for the buyer agent to pay attention. On this addendum for sale of other property, here's the scenario. The buyers are telling the sellers, Mr. and Mrs. Seller, I want to buy your property, but I need the proceeds from the sale of my home before I can close on yours. And the sellers are going to go, what? And then the listing agent's going to explain, say, okay, here's this contingency. Mr. and Mrs. Seller, when a buyer gives you this, they have until the date that they've entered in paragraph A as far as getting their proceeds. And they can tell you the day before that they didn't get their proceeds, or afterwards it'll automatically terminate and the buyer gets the earnest money back. It's the longest provision, typically, for a buyer to say to a seller, it didn't happen, I get my earnest money back and get to terminate. In paragraph A, it's an automatic termination. It doesn't require notice. It says the contract is contingent upon buyer's receipt of the proceeds. Okay, notice why do you think it's in bold? It is important. And not only that, do you close and fund simultaneously at the same time, at the same day? Not always. This is what I want you to pay attention to as buyer's agents. If you have a closing date, say, of today, and you had the 27th on here, but the buyer didn't get their proceeds on the 27th, they got them on the 28th. This automatically terminated and your buyer lost it. Do you see how deadly this is? So again, when you're a buyer's agent and they're saying, hey, we're going to close and fund on our contract by this date, you better mean that you get those proceeds, okay? If not, you'll do an amendment to change paragraph A in the amendment, okay? That's always subject to change. That's why they call it an amendment. But make sure you don't ever let this date pass. It says that the closing of this property that you're going to put the address in on or before this certain date. If the contingency is not satisfied or waived by buyer by the above date, the contract will terminate automatically and the earnest money will be refunded to buyer. Let me tell you what happened. Buyer agent was in this office. Listing agent was in another office. Listing agent got a call. Buyer said, oh, the buyers on our property need to extend the closing date. Does everybody understand? It's kind of hard to kind of think in your head at this point in the afternoon. You'll need some more treats. So what I mean is, here's the buyer here, and he's buying your property, the seller's property. But the buyers for their property come to them and say, oops, we need more time to close. Okay? So buyer agent, listing agent here, goes to the seller's listing agent and says, we need more time. Can we extend the closing? Sellers go back and they said, oh, sure, we'll extend the closing. So the buyers put an amendment to extend the closing on this property that they're buying. And this buyer, the one who's buying the middle people's property, they put an amendment in to extend their closing date. Everybody thought they were great. They forgot to extend the date in this paragraph A. Sellers were both contract attorneys. You think they read? Who said no? Who said no? You did? You were dead on. The sellers are calling me. I'm tooling back to Bernie. I'm on I-10. I'm trying to hook it out of town. The traffic's really getting bad. And I get a call from the sellers. They said, oh, our listing agent said to call you. And I thought, that was their first mistake. Because here's what happened. I'm never going to lie. I'm always going to say what is prudent, what the agent should have done. And if you didn't do that, it would be like driving a stake through your heart. And I don't want to do that ever. Okay? So here's what happened. The sellers say, I'm blah, blah, blah. My wife and I are both contract attorneys and blah, 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 blah. And I said, well, I don't have your contract in front of me. Can you get I have it right here. I said, great. Can you please tell me what the date is in paragraph A on the addendum for sale of other property? This was June 29th when we were talking. He goes, it's May 30th. I said, well, that contract automatically terminated. What? I said, yes, sir. Read that sentence to me that's right after that date. And he read it. He went, oh, well, that's, he was so tongue-tied. He said, well, we've already extended it to close. I said, that may be, sir. You extended a contract that didn't exist. And he was so flustered. He got off the phone. He says, well, I'm going to fix this. I said, you are welcome to do that. Now, I get a call like the middle, almost towards the late July. Now, again, this was like June 29th when I was talking to him, late July. And they called me and they said, the listing agent said, it funded today. I said, oh my gosh, what happened? Well, they had to extend it again. He said, and we don't know what the seller did, but man, they went directly to those buyers. I said, oh, well, as long as we don't know anything, we're just fine, huh? Everybody went forward thinking they had a contract and they closed on it. Unfortunately, the listing agent fired their coordinator because the coordinator missed that date. Now, truthfully, as a listing agent, are you not responsible for everything? Well, yeah, you are. The fact you fire somebody, that's ridiculous. You should fire yourself. You know, because that's what your job is. Even though somebody else is helping you, your name's on it. It's you. So here, I go to the agent here in this office, and he said, man, I made a big mistake. He said, I learned a lot. I said, I know. Because his buyers didn't want to lose the property. They really wanted the property. All they had to do was what? Extend that date. And that would have been the same date as the extension when they did it right there to extend their contract. So again, just pay attention to this. It's really critical. You don't want your client to come to you and say, you didn't tell me. You didn't take care of this. You didn't watch this. You didn't monitor this. And that's your job. Okay, that's the biggest problem for you as an agent. You can't say you didn't know because you all read it. And if you've never read it before, we read it together today. Does that count? Yes, it counts that we read it together. So paragraph B says, if seller accepts a written offer to sell the property. What is a written offer to sell the property? A contract. You have all the right answers today. I'm going to have to find something for you. Let me see what I got in my little purse here. Let me see now. Oh, pretty, pretty. Oh, I think I have something here. What have I got? I have something. Isn't it a pretty card? It's from Starbucks. There you go. Okay, what happens on this is the only addenda that if a seller has this addenda on their contract for their property, the seller has the right, once they accept a contract, not an offer, but they have to have an executed contract. It's a backup contract. We'll talk about that in a few minutes. But what happens is this is the only time a seller gets to come to a buyer under a contract and say, buyer, I need you to either waive this contingency. In other words, you're going to lose everything if you don't close on my property. Or you terminate, I give you your earnest money, and you go away. That's exactly what this provision in B does. And what happens is there's a fill in the blank, and it says if seller accepts a written offer, that's a contract, executed contract, not an offer. Seller shall notify buyer, one, of such acceptance, and two, that seller requires buyer to waive the contingency. Buyer must waive the contingency on or before blank day after seller's notice to buyer. We have a form for this. Of course we have a form for it. TAR provided it. It's 1912. The sellers will say to the buyer, I have a backup contract. Now, you have 2 days to either waive the contingency or terminate. Otherwise, the contract, if the seller's notice to buyer, otherwise, if the contract will terminate automatically and their earnest money will be refunded to the buyer. So either the seller waives it within those number of days or the contract is deemed terminated. So if you have buyers who have to have this on their contract, they can never leave town. Does everybody understand that? They don't get to go on a cruise ship out of Galveston. They can never leave town. Because within those number of days, they have to waive it. Otherwise, it automatically terminates. They lose it. Case in point, buyer agent here had buyers who went on a cruise. On the cruise, they got notice that the buyer now had to give either waive or terminate to the seller because the seller had a backup contract. They didn't do that. They were on a cruise. When they got off that cruise ship, they lost this property. Under this addendum, too, the buyer has to perform. The buyer has to do their due diligence during their option period, do all of their investigation, decide if they want to go forward, get their insurance, all this kind of stuff. So the buyer is going to expend a lot of time and money, and the sellers have every right. Within 1 day, we had one about a month ago, 1 day they had an executed contract. Buyers had already lined up all of the inspectors. They'd spent $1,100, and that night they got the notice from the seller. We have a backup contract. You either waive this contingency, meaning it disappears, or you terminate. And the buyers freaked out. Well, it was the buyer's agent's fault. No buyer would sign this without knowing that. Yes?
One question. If there's a requirement, you have to fill it out. When you send these addendum, you have a contingency, you have, and what is the amount of day that you would suggest there? In the blank that is included, what would be a recommended?
It's going to be an actual contract date. The buyers, their buyers are going to close on their property by that date. If they don't have a contract on their property, the sellers are going to look at it wholly differently. Because there is no contract. They're just saying to the sellers, if I don't get proceeds for the sale of a property by that date. And it is subject to the seller accepting it. If it's 60 days out, the seller may say, I'm not going to do that. Do you know what I'm saying? But if it's a closing date for their contract, you're going to make sure that it's probably a couple of days after their closing date so you can make sure they get the proceeds by that date. That would be smart to do. If they've not put the property even on the market, they're going to do guess. They're going to say, I think I'll get the proceeds of the sale. Sellers don't like that. Sellers don't like these contingencies anyway, this kind of contingency, and they may not look real kindly upon, you mean this isn't real? You have to sell your home and you haven't even put it on the market, So again, it's a very different discretion, but that date is coming either from an actual contract or what they want to project, that they would think that they will be able to close. Now on the disclosure about how many days they have to waive, I see normally 2 to 3 days. I have seen 1 day, and I think from a seller's perspective, they negotiated that, and I think I know why. The buyer probably knows they could either waive it or they're going to terminate if they don't want to risk losing everything. Okay. On the conditional approval letters, the lenders are obligated to put in writing to the party that this is conditional upon the proceeds from the sale of another property. So everybody should see it. The seller will know that. If it's not on there, you probably want the seller and you to pick up the phone and talk to the lender and say, hey, I noticed that you didn't have on this letter that they need the proceeds from the sale of their property. They're obligated to do that now. And what it could be is that the lender may say, well, I'll let the buyer advise you on that, but their being approved is not contingent upon them getting their proceeds. That's a clear indication, one, that the buyers can buy this property without selling that property. Those are different kinds of buyers. They just want the contingency. They don't need it. Yes?
So in that regard, does that mean that waiving, is that, so if they say the buyer says, I'll waive it,
They
means they just wanted it just in case, but they just still buy the property?
Exactly.
Or terminate means they could lose everything, but
Yeah.
they can't buy it.
Yeah. And there's no buyer that probably would waive this unless they had certainty that they could buy it without their proceeds, or they want to do that. Some buyers, like you said, want it, but they don't need it. They have the proceeds to have two homes, but they may not want to at the very end. When push comes to shove, they have to make that decision. But most lenders will tell you if it is a requirement. In other words, the buyer doesn't have latitude. And your seller's going to need to know that, because the next paragraph is what the sellers really need to make sure they know before they accept this. And it says, buyer may waive the contingency only by notifying seller of the waiver and depositing X number of dollars, and with escrow agent as additional earnest money. All notice and waivers must be in writing and are effective when delivered in accordance with the contract. Okay, so here's the deal. Mr. and Mrs. Seller, these buyers have to have the proceeds from the sale of this property. Okay, well, Marilyn, what does that mean? Well, here's what it means. They have to have the proceeds, but they have the right to waive it, this contingency. Okay? So when they waive it, they say, okay, it no longer exists, but they are required to put additional earnest money. And you know why? The seller can't make the buyer terminate, but why would the seller want a buyer who has to have their proceeds extend it out and wait and wait and wait? See, that's the difference. That's what sellers need to look at. When sellers know that dollar amount is not $500. It's not $50. It's not $100. It's $5,000. $10,000. Those are sellers who said, look, if I come to you and ask you to waive or terminate, you're probably going to terminate if you don't want to risk losing all of it. And you will lose all of it if the buyer needs the proceeds in order to close on this property. That's the deadly part for the buyer. Okay? The seller doesn't want to be hooked letting a buyer continue on when they do need the proceeds. That just doesn't make any sense as a seller. Now, addendums for sale of other property are not allowed in what? They're not allowed with relocation properties. Relocation companies don't want a pretend buyer. They want a real buyer without a big contingency like that. Bank-owned properties, they won't allow this. HUD won't allow. Do you see the difference? This is really one of those addendum that allows a buyer and seller to enter into a contract with so much uncertainty, because it comes down to that date that the buyer will receive the proceeds from the sale of their property. When does this earnest money, say there was $5,000 and the buyer said, I'll pay $5,000. As a buyer's agent, when are you going to tell that buyer to put that $5,000 with the title company? The same day they sign it. If they sign it on a weekend, they're going to do it Monday morning. Okay, that's how it's done. It's done immediately. No ifs, ands, or buts. That's what it would take. Is time is of the essence for this addendum? There you go. So that's why the buyers can't go anywhere, because you never know when the sellers are going to present that. And you don't want the buyers to lose it. It'll automatically terminate if they don't respond. There is a special form, 1912. The top part of that form, the seller uses it. The bottom part, the buyer uses it. And the buyer will notate on there if they waive it or they terminate. Okay? We always have a form for everything. Any questions? All righty. Addendum for mandatory membership in a property owners association. Have y'all ever seen this one? This is one of those that we see a lot. Yes?
I just got a text on a contract that got accepted last night. We used this addendum, the seller, I represent the buyer, seller is to provide those documents within 15 days. She just emailed me a link. Here's the link to the HOA docs. We're ordering the resale certificate. Need some information for you for that. Well, to me, that's not what that paragraph is about. There's more than what I could just go access online. Right?
Well, subdivision information is included, resale certificate and the subdivision information. So the link is fine. They delivered the subdivision documents, but the resale certificate better come within those number of days.
Okay.
Yeah.
And that first paragraph then doesn't give you financials and the lawsuits or that kind of thing?
The resale certificate will do that.
Okay, that includes
Yeah.
that.
Mhm. The resale certificate, that's why nobody gets to do anything with that one. Yes.
I've seen listing agents provide this document.
Yes. Let me tell you that this is, if a listing agent has this signed by their sellers before an offer comes in, they are in violation of TREC. It's misusing a form at the wrong time. The few groups that I've been telling this, top listing agents all came up to me afterwards and said, I didn't know I've been doing that. I said, yeah, well, we've been telling you, and we just stopped telling you because we're not going to tell you the same thing every time. You either do it one time. I'm not going to treat it like kindergarten. And so the sellers, those listing agents, they went to MLS and removed all of them that day because it is a violation. TREC could come after you. No listing agent will have this signed by a seller, period, until the offer is presented. Now, you and the seller can talk about your options and be prepared for it. Nothing wrong with that. But the buyer, this is a buyer-driven document. The buyer is going to make the request to the seller, and then the seller gets to counter, accept, or just reject. But you as a listing agent will never have this anywhere in your possession until there is an offer. It's not a listing document. It is a contract document. And on this document, there are different ways a buyer would like to look at it. In 2012, our then Governor Perry signed into law allowing a prospective purchaser of a property under an association to pay and get their own docs. How revolutionary. Yeah. And that was because our association and their lobbyists have been whittling away the stronghold that these owners associations have, and the condominium associations have a lot of power and authority, and we're trying to dilute it little by little. It just as you've been watching what's happened in our federal government, our state government is no different. People who say we want all of these great things at the same time, everybody goes, not so fast. I'll do a little bit at a time. And that's what they've been doing progressively every 2 years. This year they're working on the fees that are charged to a buyer, that a buyer gets slammed with at the end, and we'll talk about that in just a minute. They're trying to diminish some of the fees and make sure that they are properly scoped within the Consumer Protection Act, federal law. In other words, consumers have to be protected, and some of their fees that they're charging for these types of things are not within the norm or probably not reasonable. But on this form, here's what happens. Paragraph A1 gives the buyer the most provisions. Number one, they ask the seller to pay for all the documents and then to deliver them within those number of days. And if they do get it, they still can tell the seller within 3 days of receiving it, I terminate, and they get their earnest money back. They don't even have to say why. No seller would want that, so you can kind of see why it's negotiated the way it is. In paragraph B, it says, okay, here's the deal, Mr. and Mrs. Seller. I'm going to pay for the documents. I'm going to deliver them to you. And then I still have the provision within 3 days of receiving them to terminate and get my earnest money back. Okay, so B is different than A. A puts it all on the seller. B says, oh, no, buyer's going to pay for them and then deliver to the seller and then still tell you within 3 days of receiving them if they want to go forward or not. Yes?
Representing a buyer, see this document in the listing fees
it's always have number 4.
I understand. Don't pay attention and don't use that form.
Okay.
Your buyer's going to do what they want to do. Let the sellers negotiate. I thought we made that real clear. You're not going to use a document signed by a seller crammed down your throat. As a buyer's agent, it's the buyers who are going to be able to tell a seller, this is what I want. Then the seller gets to say yes or no or counter. Paragraph 3 says, okay, here's the deal. I've got all your subdivision information. Mr. and Mrs. Seller, I require a resale certificate updated. Would every buyer want a resale certificate updated as of the date of contract? Absolutely. Your script will never change. And so what happens, the buyer has to pay for it, give the money to the seller, then the seller has within 10 days that they've got to deliver that resale certificate, or the buyer gets to terminate and walk away. In this instance, the problem for you as a listing agent is if the seller can't do it within 10 days, you're going to have to make sure that that's modified in special provisions or some way, okay? And that's what our problem has been. The sellers have had to pay expediting fees to get it done within 10 days. Otherwise, they are in trouble. If they don't deliver it, the buyer gets to walk. Now, those are the 3 that you can see can kind of benefit a buyer, right? They get the option to get them and then walk away within 3 days if they don't like it. Now, in A4, buyer does not require delivery of the subdivision information. Subdivision information is the resale certificate and all the covenants and restrictions. Now, what happens on A4, if you are a buyer's agent and that's what the buyer and seller have negotiated, you're going to have to tell the buyer, while you negotiated that with the seller, you are still going to need to get these documents, read them all, and make a decision during your option period. That's really the best way, okay? Because you don't want the buyers to find out something and realize, oh my gosh, it doesn't allow me to rent this property. I must occupy it for 12 months. Okay, there are lots of things, and those are big, long documents, and they are required to read them because they're going to accept them. In paragraph C, the other fill in the blank, we have a situation where the buyer has to be asked by you how much of the fees to transfer the property to you, how much of these fees are you willing to pay? And the buyer will say, I don't want to pay anything more than $100. Well, anything over $100, if the seller agrees to it, the seller must pay. What is deadly for you as a buyer's agent, the fees I mentioned that developers do, they're called capitalization fees, development fees, special education improvement districts. They put all these various names. And if you don't ask as a buyer's agent before that offer is placed, are there any of those fees, that your buyer will be subject to paying them at closing and funding. And sometimes they're 0.5% of the sales price, sometimes they're 1%. It just varies. So you as a buyer's agent must ask the listing agent about it. As a listing agent, you're not going to take the listing unless you know that for a fact. Because not only should your seller have disclosed that somewhere in the seller's disclosure, maybe in section 5, but you're going to have to put it in agent remarks. And your seller does know, because when they bought the property, they got all the documents, so they can't say they don't know. Okay. We've had some problems where listing agents have said, no, there is no such thing, and at the very end of closing, it was $2,900 that the buyer had to pay. The lender should have known that too. And so the problem is that this buyer is just slapped with it, and at the very end, it is a buyer's fee. In those restrictions and covenants, it says who's going to pay the fee. It doesn't say it's negotiable. It says the buyer will pay it. So if you find that out and your buyer says, can we negotiate with the seller at time of offer, that's when you do it. You put it in special provisions, and you and the seller as a buyer will negotiate back and forth and see, can they come to some middle ground while I pay it. I am going to tell you the few that I've seen come through that it's been brought to my attention. The seller says, no, I had to pay that when I bought it. I'm not sharing it with you. And it was kind of like it was their way to get back, because the seller, when they bought it, didn't tell them. and they got stuck at the very end. And the agent, one of the agents said, yeah, I had to pay that fee or the buyer was going to sue me. So we got the whole history in one email from the listing agent who was their buyer's agent when they bought it. So again, just be aware as a buyer's agent, you better get that cleared up in an email. I would say for you to call the association, but I wouldn't trust them. They tend to give different answers on different days sometimes. I would consult maybe with the title company that has closed properties in that area, in that development. They know intimately about it, and the lender absolutely has to know. Okay, so those are other sources you can go to confirm, not just ask through the listing agent, but start with the listing agent. They should know because it should have already presented somewhere in the seller's disclosure or an agent remarks. Now, in paragraph E, when would you mark one of these boxes? If A4 is marked or A3 did not require an updated resale certificate. And what it means is the title company is no longer, their lobbyist was very strong. Their lobbyist came to Trek and said, we're not paying these fees any longer. Either the parties pay for it or we're not closing the deal. And that's what happened. So either the sellers have to pay for the resale certificate and that, or the buyer will. Okay, so while the parties didn't negotiate through A1 or 2 or 3, A4 said, I don't need them. It doesn't mean that the title company will not need them to close and fund. Personally, every buyer needs it. The resale certificate by law was required now that they have to address if they're in litigation. In other words, if they are pursuing and suing an entity or if they have been sued. And no lender will fund if there's a lawsuit. Just want you to be aware of that. And every seller of the property knows there's a lawsuit because they've been told by their association that there's a lawsuit. And if they didn't disclose that in Section 5, they're going to be in trouble. Okay? So again, you have to kind of watch. It's a lot of moving parts here, but it's very important. And buyers need to know to do the right thing to protect themselves. Uh-huh.
I know that the resale documents are very expensive. Well, I had one from condo, and should the agent go over with it with the buyer? Because they're going to have some suppression.
Well, here's what I'm going to tell you. You're going to provide the subdivision information to the buyers. They're going to read the restrictions and covenants, and you're going to say, you need to read all of these and make sure that you feel good about moving forward with this. The resale certificate, you better look at and review, and that you might want to review with the buyers because it's going to affect it. As I said, no buyer, even a cash buyer, is not even going to buy in a condominium group or an association where they're in active litigation. Because do you know what they do? If there were 10 condos and the settlement that they made was $1 million, what was the price that each one of those owners would have to pay? $100,000. Well, let me tell you what happened. We had that same scenario. They went to every one of the owners and they said, we're going to offer you 30-year financing. So they did. The seller failed to disclose this to the buyer at time of contract. So at the very end, they find out that he still owes $30,000 on the note because of the lawsuit that was involved with the association. So the buyer says, I'm not buying it unless he pays it off. And the seller said, I won't have anything if you make me pay it off. And the buyer says, well, I'm not buying the property. You're paying it off. Title company said the same thing. Those are seller's expenses. That loan and that note that they have amortized over 30 years is the seller's. It's not this new buyer. It doesn't transfer it to him. So again, we've got lots of different scenarios, and it just depends upon what's gone on with these associations. So again, don't rely upon the seller having been truthful. Make sure that you, as a buyer's agent, advise the buyer, and let's do some investigation. Let's get some questions answered on this. It's very important. Now, here's what I am going to tell you. Your poor buyer agreed to A4. They didn't do anything you recommended. Seller wouldn't let it sell the house unless they did A4. 5 days before closing, The title company says, oh, we got the resale certificate, and they are in violation. They're not in compliance. The seller isn't. What has to happen? The seller has to fix everything. Your buyer will not close on that property until the seller has no violations. Case in point, we had one, unfortunately. The seller put on a roof and didn't get permission from the association, and they put the wrong roof on. Had to have that roof removed and put the right roof on. There is no forgiveness by any of these associations, so again, just be aware. And the seller said, I didn't know, and that's not true. The seller knew because they got the documents when they bought the property, just because they didn't read them. And I don't know about you, but I've had to read those documents. We had an agent in this office who said, sure, there are investors in this association, in this units. Well, they were prohibited in the restrictions. You had to occupy the property for X number of months before you could use it as a rental property. And our attorney and I had to read every word on those 700 pages of documents. And we found the provision where, and it's nestled, it's hard to find it, and we found the provision that it says you had to be an owner, occupant, before you could lease it. You had to be there for 12 months. Turns out the attorney went and checked. They had never filed and recorded it, so they couldn't enforce it. So we got out of jail on that one. Otherwise, the listing agent would have been done for. Yes?
So where is that document? Where is it filed?
It's in the deed restrictions and the covenants. And it's important. You have to read it. It was hard to find. The attorney kept calling me. He says, where are you seeing this? I said, well, I don't think I made it up. I'll go back to it. You know how you do a billion things at the same time? That's my life. And so I had it marked, because I'm not going to print out 760 pages. I had it marked somewhere so I could go back to it, because I was interrupted and couldn't, and I had to leave it. And so fortunately, they had never filed and recorded it, and that was a godsend for us. They're deadly. They are going to make it a violation now that, you know how some leases, if they're in a condominium association or a high-rise, they say that the lease is subject to approval of the tenant? That's against the law. Yes, it is. They're gonna go down for that. That can be subject to discrimination. So that's kind of like I get to pick my neighbor kind of thing. So it's deadly. So, you know, there's lots of things that go on. We're going to yes?
Okay, it was explained to me that they were doing it to find out if there was any criminal behavior on the part of the person.
Well, the landlord gets a criminal background check. Nobody gets to sign off on that but the landlord.
So all these high-rises.
Oh, I know, honey. Yeah, I can't wait. It's all coming because they've got that on the whole docket for this time on the legislature.
Okay.
Yeah, I'm scared of that. Do you want to see if a landlord says, yes, I'll rent to you, and this person has a criminal background, that landlord is personally responsible.
Right.
And that's deadly. No landlord would do that, but we've had landlords who've approved people for various reasons, and they could be in trouble. Yes?
In the event that the buyer does not take your advice and accepts the seller's paragraph 4A4, that no documentation will be provided, and then the title company orders the resale certificate. It's provided to the buyer, but I can't find that the buyer can get out of the contract.
They can't.
So see, you're going to still have it, but you've just given away your right to get out of the contract.
Amen. That's what a contingency is all about.
So we need to explain this. Don't let them ever do that. You go on and pay for it.
Yeah, that's why I
But
said,
you're giving away, even though the title company is going to charge somebody,
that's for their benefit.
but you're not, okay, got it.
Yeah, and the thing is that no form ever takes away the buyer having the responsibility to do their due diligence. If you fail to advise them properly, that could be on you. And they can make stupid decisions even though you've advised them well, but you just need to have it documented that you advised them well. They can make a decision contrary to that. Now, the next one we're going to do is the addendum for backup contract. Remember how I mentioned that earlier. When did I mention the backup contract? The addendum for sale of other property. Because what happens is the seller can only come to that buyer under the addendum for sale of other property if they have a fully executed backup contract. Okay, and so now we're going to talk about this. Yes, sir.
I have one last question going back to the HOA addendum. Paragraph C, for all the fees you had mentioned earlier, that there are significant fees that are not,
They're not a part of the fees in that paragraph.
they're
Mhm.
not easily
No.
available to, for a consumer or buyer to look into that. So most of those fees are found in this resale certificate. Is that what you were talking about?
They're in the restrictions and the covenants. That's why you need to ask about it ahead of time, because you want to know, and the lender needs to also do their due diligence. If a lender knew about it and didn't tell the buyer until the bitter end, that's going to be pretty bad. You know, they may not have a contract until they execute a contract. They wouldn't know what is applicable to. But once they have it, you want to make sure that lender does their due diligence about that too, because no buyer wants to go past the option period if they feel like this is not what I would have, wanted to enter into contract for. Okay, the addendum for backup contract. This is a situation where buyer number 2 says to seller, I want your property and I'm willing to wait. Now, how many backup contracts can a seller have? I want to hear it. One only. How many contracts can a seller have? One. So, this backup contract is in limbo. Okay? And what I mean by that is the backup contract buyer number 2 doesn't have to perform. They're just sitting and waiting until they get told they're number 1. I have always wanted to be number 1. But I'm number 2 here, and we're always trying harder because we want to be number 1. So again, that's what this buyer number 2 is. They're just waiting to be number 1. Now, what happens on this, a couple of things. This is a contingency on the first contract terminating. That first contract cannot be interfered with. The seller can't be nasty and say, and hold it over this poor buyer number 1. I've got a backup contract. I'm not going to negotiate with you. They need to keep their lips sealed, okay? Because it's only going to cause them difficulty. If buyer number 1 felt that they were being interfered with, we've had those lawsuits too. Okay, and so again, it's usually because the listing agent's language and their text and their emails has been what we would call not very flattering or collegiate with the other party. They're threatening and saying, we're not going to negotiate with you, we've got a better contract, backup contract for more money. They go into so much detail, it drives buyer number 1 crazy. And they pick up a phone and they find an attorney. I'm going to tell you, as realtors, are we not bound to the code of ethics? You bet you are. Do you think that's right behavior for a listing agent to do that to buyer number 1? No. They can talk all they want with their sellers about it, but they're not going to act like that. That is inappropriate. So what happens in paragraph A, this is the date that the listing agent will have to provide. What is the executed date on contract number 1? Here's what happens. Listing agent says, okay, I'll give you the executed date. Listing agent goes all the way to page 8, and what do they find in that black box? Nothing. Now, your buyer's not going to make up a date. Your buyer's going to make sure that the parties have an agreed amendment that now says this is the executed date of the contract. And I don't know about you, but if I were a listing agent and I had to go back to my seller and say, oh, we failed to do something we're supposed to do, that's when buyer and seller both know the 2 agents are negligent and incompetent. And that's what truck nails you with every time. So if you don't think that that little black box is not important, sometimes we have to use what's in it. And in this instance, this is what the backup contract addendum requires. And that will be the executed date of contract number 1. So, and part of it is because we can't disclose the party who bought it because we can't divulge private agreement to another party, so they use the executed date to say that's the contract we're talking about. Paragraph B says if the first contract does not terminate on or before the date. Now, where does that date come from? the buyer gets to say, Mr. and Mrs. Seller, I'll be your buyer number 2 until this date. After this date, if I don't know that buyer number 1 has gone away, I get to terminate and get my earnest money back. Okay? And it says, seller must, if terminated on or before a certain date, the backup contract terminates and the earnest money will be refunded to buyer. Seller must notify buyer immediately of the termination of the first contract. We have a form for that. It's called TAR 1913. That's what the seller uses. For purposes of performance, the effective date of the backup contract changes to the date buyer receives notice of the termination of the first contract, and it's called the amended effective date. That would be when buyer number 2 becomes number 1. Now, I'm going to ask you a question about this. We've got a buyer who's under this executed backup contract, and you've been showing these buyers forever, and you're so glad you have them in a backup contract. Next thing you know, the buyers call you that afternoon. We were driving down Memorial Drive and we found another house. And you're going, what? We just got a backup contract. Well, that backup contract's in limbo. The problem for your buyers is if they didn't pay that option fee within 3 days of the executed date on their backup contract, they don't have the unrestricted right to terminate, and they have to stay in this contract until that date in B, and they will never have the unrestricted right to terminate. So bottom line is, every buyer under this backup contract will pay for their option fee within 3 days of the executed date on the backup contract. No ifs, ands, or buts. Gives them the right, if they become number 1, to negotiate during an option period. Otherwise, they won't have it. We had an instance where the buyer agent was told by the listing agent, you just hold that option fee. Okay, listing agent, been in the business a long time. Sweet little buyer agent had been in business about 2 weeks. She did exactly what the listing agent said. Sure enough, they get notification. They're number 1. And the buyer was so happy. Buyer agent said, well, I'm going to call the listing agent. I'm going to receipt the option fee and take the earnest money to title. The listing agent said, oh, the seller read the backup contract addendum. Your buyer doesn't have the unrestricted right to terminate. So don't let a listing agent tell you something that is contrary to paragraph 23 of the contract. It doesn't work. Don't let people tell you, oh, just drop it in the mail. Really? No option fee gets dropped in the mail. Where else does an option fee not go? Title company, you bet. I still have Alamo Title writing me notes. Marilyn, we didn't receive this first. The seller already received it. Because I would shut down a title company if they took and touched your option fee check. First off, buyer should never deliver it to a title company. It's not to a title company. It is what? To the sellers. And it's very clear on page 9 who gets to receipt it. Listing agent or broker or seller. Within 3 days of execution date. No ifs, ands, or buts. Yes?
What is your recommendation? We've submitted the backup contract addendum. We've submitted the contract. And everybody has signed off on it. So the option money is receipted on page 9 of the contract.
Absolutely.
But the earnest money is not delivered to the title company.
If they're not using the same title company, it will be. And some title companies, we've had one recently, I think Star Title, took 2 earnest monies on 2 separate contracts on the same property, which we've never heard of. So again, if the current title company who has the contract number 1 says, I will not receipt it, I think the parties probably wanted to be smart and change title companies. Okay?
So the timeline of all other commitment dates commences once contract number 2 becomes primary.
Right. They are in limbo.
So we're in OP in essence, but it has not commenced until
It hasn't
contract
yeah.
number 1 has terminated and contract 2 is the primary.
Right. And that termination option goes on and on and on. It says if buyer has the unrestricted right to terminate the backup contract, the time for giving notice of termination begins on the effective date of the backup contract. Remember, they receded it from that point. Continues after the amended effective date. That's when they become number 1. 2 goes to 1. And it continues for the number of days in paragraph 23. So you can see when those buyers called you and said they found something else on Memorial and you went and showed it to them and they said, we want to put an offer on this property, and I said, well, you're still in a backup contract on this other property. They said, well, let's go and see if this will work. If it works for this one and we really like it, then we'll terminate the backup contract and go forward with the new one. If you were a seller, would you want to know that the buyer who's presented your offer is a backup contract on another property? Absolutely. That's not confidential. Okay. You don't put it anywhere. You're going to convey to the listing agent. Yeah, that information. Yes.
I have 2 questions. So, when you say so that it's doing the backup contract, they still give them the option for money and still give them the earnest money. Do they go through all of the inspections?
Not until they become number 1. See, that's the limbo part.
So it's like kind of like get extra days. If you become, if you move from to number 1.
Then the real timeline starts to begin for all the time limits. Yeah, the option period begins once you become a backup contract and you've receded the option fee.
And the second question would be, can you amend this so like it does in the initial scenario? Where the
Absolutely.
person
You can amend the backup contract.
pushes it out.
Right.
So, okay, well, I want to push out your backup contract.
Right. Well, many times the buyers have said, I'm willing to wait longer. They might have put a date in B, but they're willing to wait longer. Then you would do an amendment to extend the date in paragraph B of the addendum for backup contract. So it works the same way. The only thing is they just kind of wait in limbo until they're number 1. Yes?
So the offer number 2, which is now a contract, it is dated,
Absolutely, it has an executed date.
even though all the other effective dates don't start.
No, yeah, but theirs is an executed
Okay, now I'm
contract.
so confused. So let's say that the buyer says that they want to look at another property, and they say they want to buy Memorial Drive, then they terminate the backup contract or withdraw the back, because they're still in the option.
They'd have to terminate, because it's a contract.
Right. So they're terminating the contract, they're giving notice to the title company to release their earnest money to them. Option money still stays with the seller who's already spent it, then they can go and write a second offer.
If they present an offer on this other property, the buyer agent can convey to the listing agent, we are currently in a contract, backup contract on another property. We want the seller to know that. But the buyers are really interested in acquiring this property. The problem for the buyer is only in the event that while they were out looking at that new property and getting another offer on it, all of a sudden they got a notice from the seller, you're number 1. What would be the worst? They would terminate under their provision in the termination option. So again, it is a difficult addendum to work from the standpoint of the buyer's requirements. The seller is just sitting very happy because in the event buyer number 1 goes away, they can rush in buyer number 2. I am going to give you one caveat. Is time is of the essence on this? Yes, it is. I am going to give you one caveat on this. We have a situation where the listing agent did try to use the backup contract over the first buyer, kind of intimidated him, told him the seller's not going to negotiate with you for any repairs or anything because we already have a backup contract, that kind of thing. Well, it turns out that the listing agent and seller failed to provide the myriad of inspection reports that the buyer number 1 had done on the property. And so what happened is they boasted a lot, and then buyer agent number 1 said, you have to disclose all of our reports to your backup contract buyer. Apparently when they did that backup contract, when it went into primary position, they walked away under their termination option. And so that listing agent came back to buyer agent number 1 and said, oh, buyer went away, are your people still interested? What do you think their response was? Never. They were so mad with the way the listing agent had treated them. And I can understand that. That's why the way you treat somebody, you know, it could burn the bridge for your seller, and that was not in the seller's best interest to do that. The last one is the short sale addendum. How many of you have ever been involved in a buyer's side for the short sale? Okay. The listing agent has to have designations and know what they're doing to be in a short sale listing agent. And that's because we have had lawsuits where listing agents were sued, and it came down to the listing agent failed to disclose to the seller, the distressed seller. Sellers under a short sale are distressed. That's a legal term. We think most sellers are distressed. And that could be probably true. Some buyers are distressed too, right? But unfortunately, the attorneys have said this is a legal description of the party. Not only have they not been paying their mortgage, they haven't been paying their taxes, their HOA fees, you know, everything. So they're not able to respond properly. And what happened is the listing agent received notifications from the lien holders, right? Because the listing agent was acting in behalf of the seller in communication with the lien holders, trying to get the lien holders' consent for this short sale. And it was determined that the listing agent received the notification from the lien holders, but they failed to give it to the sellers. The sellers got a tax bill from the IRS, and they sued the listing agent for all their taxes, attorney's fees, and everything. See, and that's the problem. If you're a listing agent, you don't get to do short sales unless you've had a designation, and most of the designations provide you wonderful liability forms to use. It is a high risk for you as a listing agent because you are working with distressed parties. If you're working with a buyer who wants to buy a property under a short sale, the only thing you're going to have to tell the buyers is sellers about the sellers. You're going to tell your buyers, look, these people haven't been paying their mortgage. They haven't been maintaining this house. They could strip it of everything. On our final walkthrough, we'll walk in and we won't have doorknobs. That's a true story. And so the buyers need to know that element. We can't control it, but let them at least be aware of that. That's the biggest problem for them. The other thing is a buyer's agent, you're going to find out from the listing agent before you put an offer in, what is the status of the seller reporting to the lien holders all of their information to be approved for a short sale. If all they're waiting for is an executed contract, your buyers are feeling pretty certain. If the sellers haven't completed that process, they're procrastinates, they're distressed, it could take forever, they may never get approval. So just so your buyers know, because your buyers are going to start performing the moment that the lien holders have provided written consent. Now, here's what happens on this one. It says the contract to this addendum is binding upon execution of the parties, and the earnest money and the option fee must be paid as provided in the contract. What I am going to tell you, the option fee for a buyer will never be credited. They lose that option fee no matter what. So a lot of times we see a very nominal amount that a buyer is going to give for option. And the reason for that is no lien holder will approve any money, and the lien holders would have to reimburse the buyer at closing. So that's why you have to put in paragraph 23, will not be credited. The buyer will never get that option fee back, but your buyer needs the unrestricted right to terminate. This is one of those deadly properties where they must do extreme due diligence in finding out the condition of it. So it says that this contract is contingent on the satisfaction of seller's requirements under paragraph A2 of this addendum. That's the lien holder's consent and agreement. Seller shall apply promptly for and make every reasonable effort to obtain the consent and agreement, shall furnish all information and documents required by the lien holder. Except as provided by this addendum, neither party is required to perform under the contract while it is contingent upon lien holder's consent and approval. So it's the same way that short sale addendum is. It's just kind of sitting in that limbo state until they are told that the lien holders have agreed to the contract. Now at that point, the contract gets an amended executed date, and all the dates in that contract will go forward. Many times we see where that has to be amended right away because they were waiting so long for the lien holder's consent that all the dates in the contract are no longer applicable for a buyer. It says D, if seller does not notify buyer that seller has obtained lien holder's consent and agreement on or before, this is the date the buyer is willing to wait. Some buyers want to wait 60 days. Some don't. Some want 30 days. So this is the date that the buyer is willing to wait. Again, they've already paid their option fees, so they have the unrestricted right to terminate, but there is a provision that says, I'm only going to wait so long, and then the contract will terminate and the buyers will receive their earnest money. The issue that we have in this short sale process is you also, as a buyer's agent, you need to know how many liens are on this property. Well, I'm going to tell you, you can rely upon a listing agent or you can pay for a property search from the title company. That's the way to go. Get it ahead of time so that that buyer knows at time of offer, we've got 2 lien holders. They have an IRS judgment. They have, do you know what I'm saying? That they're going to know full potential issues that the seller may have to clear in order to get this lien holder's rule. We had one that went on for 2 years in here. It was a multi-million-dollar property, and there were so many liens and judgments. On any given month, they would get certain approvals, and then the one lien holder would say no. Then the HOA would cough up and say, no, we're not going to do this. So it was one of those things that it was just devastating. When it finally did close, I thought the agent was pulling my leg because I said, you're not talking about something we talked about last summer. Yeah, I've been working on this for 2 years. But it can be complicated from a buyer's perspective. And so just remember, while the seller is in the worst position here, obviously, and the listing agent, because of how deadly all of this is, making sure everything is approved, the buyer really has to be realistic about this. Most of the time, on the final walkthrough, we've had investors who buy a lot of these properties. The investor walks through and there are no toilets, no chandeliers, no doorknobs. We had one property totally stripped. It was a multi-million-dollar property, and at walkthrough, it was pretty obvious that the sellers were a little upset because they literally had stripped this home of doorknobs too. That's pretty hard to do. I mean, that's a lot of work. But again, you never know. We had one that removed the reverse osmosis. The seller had sold it, and the buyer was an investor, and the buyer demanded it be returned before they closed and funded. And the seller and the listing agent said, well, you're not going to get it. They already sold it. And she doesn't have any money. So it is what it is. That investor knew that could be this is not like their first time that they've been involved in this. But it's real hard to force another party who is under a short sale. They are distressed. They're not making good decisions. That's why they're in the shape that they're in. So again, don't paint a real rosy picture or think this is a really good deal, because it might not be in the end for your buyer. Again, everybody understand that these addendum are important for us to understand. The timelines are really critical. It's not just reading it and knowing it. Do you know what I'm saying? Your buyers and the sellers could read it, but they're not going to understand how it has to be applied. So that's your part, and that's what you need to make sure you know it very, very well so that you can explain it to them so they can agree to it and make it binding in the contract. You don't want them coming back and saying, well, you didn't tell me that. Reading it to them can help. Reviewing it with them is very important. Is there another question that was back here? Yes, ma'am.
The properties are already upside down, and what in the future?
Pardon me?
The properties are already upside down, right?
Right, the short sale, that's what it means.
And the agents, what is on the commission for?
The agent, what, on the Okay, the agent gets paid by the listing agreement. Now, what I am going to tell you, HAR requires a property posted in MLS that is subject to the lien holder's approval. You better have the language in MLS that says that the cooperating broker understands that this is the only time commission could be changed, and the buyer agent would have to accept it. So in other words, if MLS offers a certain percentage, but it is subject to short sale, the language has to be there, because as an agent, you're going to accept what the lien holders give. It's not a certainty what was in the listing agreement. The lien holders get to change that. It's the only time that we see that. The lien holder is going to make the final decision on what the compensation is. I've seen it less than that. I've seen it split where each agent got $1,200. Yeah, it just depends. And here's the thing I'm going to tell you. Do we receive compensation for all the hard work that we do? Sometimes we don't. Sometimes we have to make a decision that's in the best interest of our client. And that's what these types of transactions, like the short sale, those are transactions where the agents are going to step back and say, will my seller not be able to sell it if I don't agree to what the lien holders are now offering as compensation? And the buyer agent is going to have to say the same thing. And so it's one of those things. You better be ready for that as an agent who represents a buyer who wants to go forward on a short sale, because that could be subject to it. And it's not in your buyer's best interest to say, I'm not going to go forward if they don't give me what I want. That's your interest first, and your interest can never be first in the transaction. It's always about who? Your client. But they have the authority to change it. Only time, other than the brokers. Yes, sir.
Going back to the HOH addendum on the report, in paragraph it states, title company or its agents authorized to act on behalf of the parties to obtain subdivision information. So agents, that would mean like the leasing agent.
Correct.
Pretty much.
Mm-hmm.
I had a client of mine, before she was busy at work, she asked me if I could go through the system to obtain the CCRs and covenants and all that.
Well, hopefully she didn't make you pay for it.
No, she did pay.
She paid, yeah. And we do a lot of times help our clients. If, like you said, if they said, can you go and get them, I can't get to them and get them and deliver them, yeah, we're going to do that. That's in the best interest of our clients. Any other questions? Okay, well, next month, I'm going to scare you. I didn't do a good enough job today. Y'all are too many of you are too smiling still. I know that you haven't figured it out. But what we're going to do next month is we're going to go through I'm going to do partial presentation of a counsel from NAR who came in talking about cyber theft and your emails being hacked and agents being in trouble. And so we're going to go through part of their PowerPoint presentation, and then we're going to do some Trek legal update cases, and you're going to say if the agent did a violation and what they did. So now here's what happens. When I go through these, agents usually can laugh at the agent who got the violation. They see it very readily. But if you had your transaction played out in this Trek case, would you be that willing to laugh about it? It seems real obvious to us when we look at other people's mistakes, but I think it's good for you to kind of see Trek's leanings on this. As I said earlier, Trek feels that the minute a party tells us you're fired, we are fired. Agency has ceased. I understand that. But all our private agreements, our buyer tenant agreement and our listing agreements, those are private agreements. Who gives us those to use? TAR, our association. And our association says, I provided a form that says the parties can terminate, but it's based on the terms the parties reach to terminate either a listing or a buyer tenant agreement. Okay? Where Trek says, no, if your client fires you, you're fired, and you should never stand in the way or prevent somebody from entering into agency with another. So you see how conflicting that seems? Our association provides us the documents, and yet Trek is saying, oh, but you can never do this. And that's not unlike Trek. Trek doesn't like to give you a lot of guidelines. They like to nab you each time under separate conditions. While personally, I'd love them to list, if you do these things, you're going to get a violation. You're going to get oh no, they like to leave it up to their discretion. And as I said, over the years, I've been a participant watching what Trek has done, and Trek has changed. They're getting very aggressive now. They're not giving you the latitude. Well, I did review that with my client. They're going, nope, if you didn't prove it in writing, you never did it. So, they're changing, and because of that, you need to be kind of an aware, what is Truck's position on some things, and maybe you'll see that I'll never do that, because you don't want to get in the same position that these people had all these violations and fines on stuff like that. So you guys have a great day and go out there and have a wonderful end of month. I need 5 closings from each of you by Friday. That'll work, huh?
We need everybody's signature on the sign-in, please. There were 4 passed around, if you can bring them up.
That will help.